Hello, law students and legal practitioners. Today, we will analyze the case of Nuval versus Guray, GR number 30241, decided by the Supreme Court on December 29, 1928. Let's begin. Here are the legal doctrines of this case. A judgment in a voter exclusion case is not res judicata in a subsequent quo warranto proceeding questioning eligibility to an elective office, where there is no identity of parties, subject matter, or cause of action. Residence, domicile, for election purposes requires actual physical presence coupled with the intention to reside permanently. A person who abandons a former residence and acquires another cannot regain the former without re-establishing residence for the statutory period. In quo warranto proceedings involving elective offices, the court may declare the election of an ineligible candidate void, but cannot proclaim the second placer as elected, absent statutory authority. Here are the relevant facts of this case. Petitioner Gregorio Nuval and respondent Norberto Guray were candidates for municipal president of Luna, La Union in the June 5, 1928 elections. Guray won by plurality. Prior to the election, Nuval filed a petition for exclusion of Guray from the voter list of Luna, alleging lack of the required 6-month residence. The Court of First Instance dismissed the petition, ruling that Guray was a resident of Luna. The decision was summary and unappealable, so Guray remained on the voter list. After Guray's proclamation, Nuval filed a quo warranto action under Section 408 of the Administrative Code, alleging that Guray was ineligible for office for lack of 1-year residence immediately preceding the election, as required for municipal office. The trial court dismissed the quo warranto petition on the ground of res judicata, relying on the earlier voter exclusion proceeding. Nuval appealed. Issue 1. Whether the earlier voter exclusion judgment barred the quo warranto proceeding on the ground of res judicata. No, there was no res judicata. Res judicata requires identity of parties, in the same capacities, subject matter, and causes of action. In voter exclusion case, Nuval acted as voter and candidate, Guray as registered voter. Issue was 6-month residence for suffrage. In quo warranto case, Nuval acted as defeated candidate, Guray as elected official. Issue was 1-year residence for eligibility to office. There was no identity of capacities, objects, or causes of action. Thus, res judicata did not apply. Issue 2. Whether Guray possessed the 1-year legal residence required to be eligible for municipal office. No, Guray was ineligible. Residence is synonymous with domicile, requiring physical presence and intent to remain permanently. A person who abandons a residence must reacquire it for the full statutory period. Guray accepted appointment as municipal treasurer of Balawan, where he transferred residency, voted there, and officially declared residence in Sedalas. Although his family later moved back to Luna and he visited them nightly, Guray continued to reside in Balawan officially until his resignation on February 16, 1928. Hence, by election day, June 5, 1928, he had not completed 1 year of residence in Luna, rendering him ineligible. Issue 3. Whether the second placer, Nuval, could be declared the winner after Guray was found ineligible. No, the second placer cannot be proclaimed elected. Under the election law, only the candidate who obtains a plurality of votes may be declared elected. Quo warranto in elective offices determines eligibility, not who should replace the ineligible candidate. On motion for reconsideration, the court amended its decision and removed the declaration proclaiming Nuval as winner, holding that the office must be disposed of according to law and not by automatic succession of the second placer. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.